Hello and welcome to the Beresford booth weekly webinar. This week we are going to talk about Revocable Living Trusts Explained. My name is Sherry Bosse Lueders. I'm an attorney in the estate planning and probate group here at Beresford booth. Let's go ahead and get started. A lot of people have heard about revocable living trusts, but not everyone has a good sense of what they are. And there's a lot of misinformation out there about revocable trusts. So what can a revocable living trust do? A revocable trust can hold title to real property and other assets. A revocable trust can direct the distribution of trust assets on the death of the grantors. And a revocable trust, if it's properly funded, can avoid probate. So let's talk about vocabulary when we're talking about revocable trusts. I've already mentioned one of those vocabulary words, grantor. The grantor is the person making the trust. They are granting the property to the trust. The trustee is the person in charge of administering the trust. They're being trusted by the grantor to administer the trust pursuant to the trust terms. What does a trustee do? A trustee invests assets, makes the distributions to the beneficiaries according to the terms of the trust. The trustee will file any taxes that the trust is required to file, and the trustee is going to maintain trust records so that there's a good record of what the trustee is doing in relation to the trust. The third main vocabulary term to know with a revocable trust is beneficiary. The beneficiary is the person entitled to receive trust distributions. Revocable trusts do not provide asset protection. I think that is one of the most common misunderstandings related to a revocable trust. And when you have a revocable trust and you transfer assets to that revocable trust, because it's revocable, will not protect assets from creditors, and it will not exempt those assets from estate tax because the assets in a revocable trust are not actually considered to be outside the estate of the grantor. And I will get into that in my next slide to talk about why that is. One thing I did want to note in terms of Washington estate tax planning, a revocable trust can include a credit shelter trust that's funded on the death of the first spouse in the same way that a will does. This is sometimes called a disclaimer trust. And what the disclaimer trust or credit shelter trust does with a married couple with a revocable trust is allow the surviving spouse, when one spouse dies, to create an irrevocable trust. That's the credit shelter / disclaimer trust that will hold the deceased spouse's estate tax exclusion amount. So what are the benefits of a revocable trust? Why have one? The revocable trust, if it's properly funded, will avoid probate of the grantor's estates. And why avoid probate? Most families are interested in avoiding probate to avoid the cost of the probate. Although one thing to mention is that Washington has what's known as non-intervention probate, and that's a streamlined probate process that's available for estates where particularly there's a will and the nominated personal representative in the will is applying to the court to be appointed to administer the estate. When that happens, probate in Washington often occurs without court supervision. It's not to say that the personal representative doesn't have to follow Washington law, but there's not a lot of court supervision and it can be fairly inexpensive. That said, there are estates that are more complicated, certainly estates where folks own property in multiple jurisdictions. Once someone owns property in Washington and a beach house in Oregon, their estate then would need to be probated in both Washington and Oregon under a will, but with a revocable trust, no probate would be needed if the trust held title to the properties in Washington and in Oregon. So that is certainly where avoiding probate can make sense. And the other primary benefit of a revocable trust is privacy. A will is public record when it's filed with the court for a probate. A revocable trust is typically not going to be part of the public record. When someone has a revocable trust, there's typically what's known as a pour-over will, and that's a will that just says everything goes to the trust. What gets filed with the court is that pour-over will that says everything goes to the trust and not the trust itself. That means that the distribution terms are not part of the public record and don't necessarily have to be known by individuals outside the trustee and the grantors and those beneficiaries receiving distributions. What are some pitfalls with having a revocable trust? The biggest single drawback to revocable trusts, other than the cost incurred in setting one up, is that a revocable trust, if you're using it as your primary estate planning document, is going to be there for the rest of your life. And if you fail to title your real property in the trust or organize your accounts so that they're either titled in the trust or have the trust as a beneficiary designation, a probate's going to be needed in order to transfer that property to the trust so that the trust can distribute the property. Another downside of a revocable trust, again, failing to coordinate beneficiary designations with the trust. And the third downside of a revocable trust is that they can be unnecessarily complicated for folks who have relatively straightforward estates. They're complicated documents, certainly more complicated than a simple will. And the cost of setting up a revocable trust and transferring property to the trust will almost always exceed the cost of having a simple will. So let's talk a little bit about revocable trust administration. And I'm starting out with I'm going through the phases of a revocable trust. So during the grantor's lifetimes, I'm going to use as my example Jane and Charles Bingley, who are a married couple and they've set up a family trust. Jane and Charles are the trustees and the beneficiaries. They live in Washington. When they set up their trust, they transferred their house in Edmonds to their revocable trust. A few years later, they buy a beach house in Cannon Beach, Oregon. They title that beach house in the trust. They don't have a separate tax return for the trust when they're both still alive because it's being administered under their Social Security number. Charles dies, sadly. What happens on the first grantor's death? There's no probate needed of Charles's estate because that revocable trust will allow the trustee, who's Jane, to continue to administer their assets. Charles and Jane had a Washington taxable estate, and Jane decides to fund the disclaimer trust that's provided for in their revocable trust with $2.193 million, which is Charles's Washington estate tax exclusion amount, in order to fund this marital trust. The marital trust is an irrevocable trust. Jane works with her CPA to get a new tax ID number for the marital trust. She's the beneficiary of the marital trust for her lifetime and will receive income distributions from that. Everything that didn't get transferred to the marital trust is now part of the survivor's trust. Jane is the beneficiary and the trustee of the survivor's trust. The survivor's trust is still revocable. So, what happens during the administration by just the surviving grantor? Jane decides to move to the Oregon Beach house. She amends the survivors trust to provide that instead of having everything get divided equally among their 5 children, she's going to have 10 shares and have her 5 grandchildren receive distributions on her death as well. It's a revocable trust. Jane can revoke the trust status of assets. She decides to transfer her house in Edmonds to her sister Lydia. It's now no longer in the trust. Jane could have revoked the entire trust, but she decides not to. And she's continuing to receive income distributions from the marital trust. And as a reminder, that marital trust after Charles's death is irrevocable. Jane can't change the terms of the trust. She can't change the distribution, and she cannot completely revoke that marital trust. Jane dies. There's no probate needed for Jane's estate because, again, her assets were all properly titled in the trust. The survivor's trust is what constitutes Jane's estate. So the marital trust on Jane's death will be distributed to her 5 children under the terms of the trust. The survivor's trust, because Jane amended the trust as to the survivor's trust after Charles died, will now be distributed to a grandchildren's trust as well as to her children. Under the terms of this hypothetical trust, both the marital and the survivor's trust terminate on Jane's death. Jane's estate will owe Washington estate tax if the survivor's trust assets exceed $2.193 million on her death. In summary, the benefits of a revocable trust are that a revocable living trust, if properly funded, can avoid probate. It provides a greater degree of privacy than having a will in terms of the distribution of the estate assets. And a revocable trust is an entity that's able to hold title to real property. The revocable trust will not protect assets from creditors or remove assets from your estate for estate tax purposes. It also does not avoid family conflict necessarily. If a family is going to have conflict in the probate of an estate, very likely that conflict will still be there in administration of an estate with a revocable living trust. If you have any questions for me, my contact information is available on this slide. I'm also simultaneously publishing a blog post on our firm's website today that will include a lot of this information about revocable living trusts. Thank you very much for your time, and I am more than happy to talk with anyone about revocable living trusts.